My Lords, in the debate on the strikes minimum service legislation and the regulations made under it, sometimes the rationale for the right to strike gets overlooked. Lords, I'd like to cite to your Lordships three very short passages, not from Marx and Engels or Sidney and Beatrice Webb, but from the highest courts in the United Kingdom and in Canada. These passages are very short. First of all, a case in 1942 in the Judicial Committee of the House of Lords called Crofter, Harris, Tweed and Veatch, in which Lord Wright said, "Where the rights of labour are concerned, the rights of the employer are conditioned by the rights of the men to give or withhold their services. The right of workmen to strike is an essential element in the principle of collective bargaining." Lords, the second authority I want to put before your Lordships is a case in the Supreme Court of Canada in 2015 called the Saskatchewan Federation of Labour and Saskatchewan. And in that case, the Chief Justice cited an earlier case in the Ontario High Court with approval, in which this was said: "Freedom of association contains a sanction that can convince an employer to recognise the workers' representatives and bargain effectively with them. That sanction is the freedom to strike. By the exercise of that freedom, the workers, through their union, have the power to convince an employer to recognise the union and to bargain with it. If that sanction is removed, the freedom is valueless because there is no effective means to force an employer to recognise the workers' representatives and bargain with them. When that happens, the raison d'etre for workers to organise themselves in a union is gone. Thus, I think the removal of the freedom to strike renders the freedom to organise a hollow thing." And finally, my Lords, in a later passage, the Chief Justice said this: "The right to strike is essential to realising the values and objectives of freedom of association through a collective bargaining process, because it permits workers to withdraw their labour in concert when collective bargaining reaches an impasse. Through a strike, workers come together to participate directly in the process of determining their wages, working conditions, and the rules that will govern their working lives. The ability to strike thereby allows workers, through collective action, to refuse to work under imposed terms and conditions. This collective action at the moment of impasse is an affirmation of the dignity and autonomy of employees in their working lives." Lords, as your Lordships well know, collective bargaining operates very successfully in the fire service, including in relation to incidents that may occur when strikes are called. Those issues are negotiated, as are terms and conditions, and most recently, of course, pay. But the effect of these regulations is to remove the right to strike from a large proportion of the staff of the Fire and Rescue Service. For example, as the Noble Lord the Minister has pointed out, 73% of appliances and crew must be available as on a non-strike day. And I just raise as a question, in my local fire station, there are 3 appliances. So the application of the 73% rule means that all 3 of them must be present and available and fully crewed on any strike day. But in addition to that, 100% of control room staff must be available, and 100% of those staff whose job it is to work national resilience assets such as high volume pumps and I think aerial ladder platforms as well. So the effect of these regulations will be to diminish the bargaining power of the Fire and Rescue Service workers and their union. That will result in worsening terms and conditions, and that will lead to difficulty in retention and recruitment. Lords, the United Kingdom has ratified ILO Conventions 87 and 98, which protect the right to organise and to bargain collectively. They are two of the 5 fundamental conventions of the ILO. And the UK has recently reasserted the importance of those conventions in the trade and cooperation agreement it reached with the EU in leaving the European Union. And let me just refer to 2 sentences from that agreement. In Article 387, subparagraph 2, the obligation on the EU and the UK is this: a party shall not weaken or reduce, in a manner affecting trade or investment between the parties, its labour and social levels of protection below the levels in place at the end of the transition period, including by failing to effectively enforce its law and standards. And the words labour and social level of protection are defined in Article 386 as including the fundamental ILO conventions. And in Article 399, subparagraph 2, each party commits to respecting, promoting and effectively implementing the internationally recognised core labour standards as defined in the fundamental ILO conventions, which are, and then it summarises them. Lords, what's clear is that these regulations will lead the United Kingdom to be in breach of its international legal obligations. It is true that the ILO jurisprudence permits a state to adopt minimum service legislation. However, that is on one condition, and that condition has a number of aspects, but the conditions for it are, firstly, that the minimum service level must be the subject of negotiation between the social partners. Secondly, the fulfilment of that minimum level of service in any particular firm or enterprise must be the subject of negotiations between the unions and the particular employer. And thirdly, in the event of disagreement, there must be an established method of resort to either judicial or arbitral resolution of the failure to agree. And that applies in all the European countries in Western Europe. There is a fourth element to it, which is that where workers are deprived of the right to strike, such as, in our case, control room staff, there must be compensatory measures adopted by the state which bars the right to strike. And the compensatory measures are the ability to seek arbitration, which must be speedy, binding, independent and impartial. None of those conditions are available under these regulations or indeed under the Act itself. So I ask the Noble Lord, the Minister, how can the UK be said to uphold the rule of law in the face of what is a clear breach? And how is the government going to explain this discrepancy to the European Union?